May it please the court, Wendy Buffington on behalf of the state. Is that too, I should put that down a little maybe, is that better?
Hold on a second, I think we're getting some feedback.
I turned it up, maybe I shouldn't have. Okay, does that work?
That's better.
Okay. I'd like to reserve 5 minutes for rebuttal, please.
All right.
Okay, first of all, state's appealing the trial court's granting of a motion to suppress in this case, recognizing that the standard of review by this court is presuming that the facts are correct when supported by the evidence, but this court reviews the law de novo, and it's the state's position that the trial court in this case misapplied the law by requiring there to be a specific identifiable emergency when the officers entered the apartment in this case. So, briefly, the facts of our case are that our law enforcement officer, Kathy Lovelace, is on patrol in Paradise Village in Treasure Island. She has a specific home that she is performing a house check on Haven Point. Now, there are two roads in this community, Haven Point and Sandy Hook, and she testified that she goes in one way, typically comes out the other way.
Let me ask you a question, because my reading of the record indicates that she went to a residence that she had knew about and was called there because the residents were out of town.
Yes.
And they wanted her to check on it.
Yes.
That's a little different than patrolling, isn't it?
She says she does this twice. It's 2 times a week. She does this specific house checks, which she was doing there. But this is her regular patrol of this community.
Okay. Well, was there any other reason for her to go by this residence of Mr. Pike's, but for the rumor of drug activity? She wasn't called there. There's no 911 call. There's no neighbor stopping her, waving her down.
Right.
So what's the basis for going by there in the first place?
There are 2 roads in this community. It's a townhouse condominium community. And she does testify expressly that we have 2 roads, Haven Point and Sandy Hook. They're connected. Now, she could have done a U-turn to go back out Haven Point, which there would be no point for her. She identifies herself as a community policing officer without the assignment. So part of her duties are to community police this area, make contact with people. She says she's very well known. Obviously, she's had 2 reports from specific residents of this community who know her, who've come to her to say, we believe that there is drug activity going on.
She's not in the drug division.
No, she isn't. Right, so she passes that along.
Detective Taylor, who's in the drug division, doesn't seem interested in this house at all, because when they call him about the open door, he doesn't even show up. So what are they doing at the house with the open door? They doing a drug investigation?
No, definitely
a burglary
not.
investigation? What?
Well, that's the point, that they know that this is unusual, and this court's held at an open door.
Is it unusual for this residence?
Yes.
How so? Well, what's the prior information about this residence that it would be unusual for them to leave the door open?
She drives
It's
by
like
it.
you going home from a trip. You've taken a long trip. Your neighbors are taking care of your dog or something like that.
Right.
You walk in, you leave your front door open, there's mail on the floor of your house.
Right.
You go across, you hadn't seen your neighbor in a while, and then you start talking about something
Right.
else, and you leave your door open. Do you expect the police to walk in your home and open up doors inside your home?
What I may or may not expect, and what the Treasure Island Police Department policy may be and how it routinely is employed is irrelevant to the facts that they were looking at this day. So her
But
facts...
what are the objective facts?
Objective facts. Okay, the light on upstairs, the door standing wide open, a pile of mail. It's 7:30 in the morning. The mail hasn't come this day, so it's come previously. Maybe a couple days worth, maybe just 1 day's worth. Car in the driveway, so it looks like someone should be home, but there's no activity. It catches her eye.
Did she run the tag of the car?
There's no testimony that she does that, no.
Okay, so we don't know if the car belongs there or not. Did she do any other police work other than look at an open door and see a pile of mail?
She is in this community all the time. She knows this unit. She says specifically about this unit, this was unusual for this unit, for this door to be open like that. And that's what caught her attention. And after the fact, she notices, oh, lo and behold, this is that unit 511 Sandy Hook that I had the 2 informant tips from. My citizens who live here and know me and told me we suspect drug activity.
But do those tips give you probable cause?
No, because we're not doing that. I mean, that is not the point of this entry. And how do we know that? We know that they're not operating under probable cause and exigent circumstances based on the meth house, which this court said, you know, it's inherently dangerous, right? So,
Well, let me ask you this. You would agree that probable cause is based on objective facts?
yes,
You would also agree that reasonable suspicion is based on objective facts?
yes.
So are you saying now that under the fear medical emergency, it's based on the officer's subjective intentions and
No.
what they subjectively believed?
No,
Okay, so you would agree with me that there's an objective basis applied to this exigency?
yes,
Okay. Other than the open door and mail and a
Yes.
light on and all the other cases that you cite, which has law enforcement summoned to a residence. So there's an objective basis to be there in the first place, either via a neighbor, via a relative, via a concerned citizen, informing law enforcement there's criminal activity or there's an emergent situation.
right.
What do we have here?
We don't need the call because she's there. That's what she does routinely. She patrols this place. She's a patrol officer. She goes in and out of this community. So the fact that she sees it, even if we suggest that she was intentionally looking for it, which I think is completely unreasonable interpretation of the facts, because she's a 35-year police officer. She's in drop. She's looking to retire. She doesn't want to go rummaging around in some meth
Well,
lab.
and this is what, let me suggest this.
Okay.
I get the impression that the state is asking us now to retry the facts of this case.
No.
Because in looking at the judge's order, it's quite clear that the judge rejected the testimony of the officers. In fact, in her order, she said it is obvious from the testimony that the search conducted in this case was not a routine welfare check. So she came to a factual conclusion based on the testimony that's been presented. So as the trier of fact, she reached that conclusion. And I gather now the state doesn't like that conclusion and wants us now to retry you. Just by virtue of your last answer, here's this officer, why would she lie? Why would she do that? Isn't that more into the factual issues?
Well, the trial court does have to have some factual support for her findings. And she says there was a choice that she went down, that this officer went down this road. But let's ignore it. Let's put that aside, because the state is not asking this court, you know, to retry the facts of the case. The state is only asking this court to look at the law that was applied. And the law that was applied was the incorrect law, because the court was requiring there to be a specific identified emergency. And Riggs, out of this court, where the Florida Supreme Court adopts that articulated feared medical emergency, there's no specific emergency there that they can identify. They don't know what it is. It's very specifically, the deputy in that case knows the child wandering around.
Yeah, but there's a 4-year-old child wandering around naked
Right.
early morning
Yes.
in an apartment complex who
Which is why-
obviously has parents there.
Right.
And the police officers are looking for a caretaker or a parent. This police officer sees an open door of a condo she's never been into and she's never met the residents. She goes up, sees mail. There's no blood. There's no sign of forced entry. There's nothing unusual there other than an open door with mail and a light on upstairs, and it's in the morning on November. We have no photos of the door,
We do.
no photos of the mail. It's not in our record.
We do have photos of the door. You don't have the door, but there is no mail.
We have
in
no
that
photos
photo.
of this alleged pile of mail. I don't know
Right,
if it's
that's true.
3 feet high or 2 inches high.
Right. We don't know. It's not there. But we
But
know.
give me your best case. Give me your best case in this.
Well, my best case.
Give me the best sites you got. Riggs, we have
Riggs,
a naked young child.
Riggs, Zakruski, both of these, the fact that there's an uncertainty, that they don't know what they're encountering. They know there is something unusual. They're like, this is not right. Their first response, both of them, is burglary. The open door in the residential area, they're thinking a burglary. So they watch the,
So a burglar is going to leave the door open when he burglarizes the house. So he's going to leave the door open while he's burglarizing a home?
if he's in the process of bringing things out.
Okay, do we have that in the facts?
No, because we have the officer, this catches her attention, that's it. She's on patrol where she has a right to be, whether we ascribe some kind of, pretextual intent or not. And it is important to note, it's just 2 roads, and she testifies it's just 2 roads, and this is the usual way she goes out.
Where's this alleged burglar going to take the property out of the home? She didn't check the car. She didn't check the tag. She has a computer in her car to check the tag to see if it belongs to Pike or someone else. So Is this alleged burglar going to put it in the car in the front drive or somewhere else?
It's not a matter of having probable cause to believe that there's a burglary. It's a matter that this situation, the open door, the mail, the light, the car, it alerted her to what is going on here. So she continued to watch it because people generally don't leave their door open. Maybe if they've got, walk the dog, get the newspaper, but they would be around. And so 10 minutes goes by before Deshay comes and before they actually enter. And the fact that she calls Deshay, they don't enter on their own. Deshay talks about, you know, we get backup when we go in, and they're clear they do this all the time, right? And that's what offends the court, that, you know, they are entering based on the open door. But we're not looking at strictly the open door, because we are looking at our totality of the circumstances. Were they objectively reasonable in entering for the limited purpose of ensuring there was no ongoing burglary or medical emergency in there? And Riggs allows that, definitely, when we have a situation which we don't know. We don't have to know.
But Riggs, the law enforcement was summoned there.
And she was not summoned because she's there. Would it make any difference if we waited an hour and a neighbor called?
But every case that you cite, law enforcement is summoned there. Please give me a case on point here where law enforcement stumbles upon an open door without blood, without a neighbor saying, "I hear screaming," without hearing any moaning or groaning or any indicia of an emergency.
Now, those emergencies, Your Honor, those are the classification of the exigent circumstances where there's an identifiable ongoing emergency, not this community caretaking situation, feared medical emergency, whatever we may want to label it, where they are just investigating with their peacekeeping hats on, not their investigative hats on.
Where is there a breach of the peace in this particular case?
There is a concern for who's ever inside there, and they do know that they've had this fresh tip of a meth lab. And they do know that not only...
that didn't matter.
It did figure in the totality of the circumstances. It did figure in when she Lovelace first sees it and thinks burglary, and then she's like, oh, this is the address, meth lab, maybe there's a drug overdose or something else going on in there. And we have Deshay say that the meth fumes are toxic. So
Did the CI or this informant say that they were taking drugs in there or selling drugs?
We don't have a lot regarding
So
what
law enforcement doesn't know if this particular person who allegedly lives there is consuming his product.
He doesn't
rather
have to
than
be consuming it, because if he's making it, he's creating the fumes that create a danger to everyone and create a danger to himself. So therefore, that heightens their concern that maybe this person is disabled in there. In the state's reply brief, we cited a case where somebody was overcome in a meth lab by fumes. So there was that potential. So looking, was it reasonable for them to go in? And are they like...
But that was the case where they were under surveillance, and they were actually seen purchasing ingredients for meth at a particular store, and they were seen transporting these ingredients for meth back to the target home that was
Right.
under surveillance.
Right, that's this
We
court's...
don't have a drug investigation in this case at all because Detective Taylor was not interested.
I would not say that that is accurate, Your Honor, that we don't know what Detective Taylor was doing, but that was an ongoing situation. They just got that tip the day before. I submit that they should have, at that point, they could have gone right in, and under Barth, where they have like an identified person who's come in, I've seen it with my own eyes, a meth lab, you're in this condominium complex, they could have secured it then.
Without a search warrant.
Yes, under Barth, absolutely. But we did not proceed on that theory below, because we proceeded on the basis for while the officers were going in, and they were going in, these are patrol officers, again, this is not a drug investigation. They're going in on their welfare check duties.
Let me go at this maybe a different way. Let's say that we were to agree with you and reverse and say the trial judge got this wrong as a matter of law. So how could the opinion that we'd have to write be limited in such a way that we wouldn't be creating now an open door exception to the warrant requirement, so that any time the police are out driving around and they see an open door, they can go into the house to check it out?
All this court would have to do was apply the totality of the circumstances, whether it was reasonable for these officers to go in based on the limited scope of their search to ensure there was no ongoing burglary, which they both testified was their first fear based on these circumstances. And again, they are familiar with this. Lovelace is specifically familiar with this place, this unit. I've never seen that door open like that before.
Well then, if that's the case and that's the way we write the opinion, doesn't that go back to Judge Kuzam's question about how we retry and decide what the effect of the totality of the circumstances is ourselves and just disregard the trial judge's findings of fact here?
No, because,
No?
because the only issue that we are looking at in the trial judge's order is her requirement, based on language from Riggs, but not the facts of Riggs, that there had to be an identifiable emergency going on, and that because they couldn't identify specifically an emergency going on, that it was speculative, because it's the feared medical emergency. That is it. They didn't have to. Was it reasonable for them to go in based on what they saw and what they knew at that time, for the limited purpose of this limited search to ensure those two things that they feared were not going on? In Riggs, and again, yes, we did have a call, but we didn't need a call because we had the person there. The officer there said, you know, we don't know, is it child abandonment? Is there something wrong with the caregiver? Either way, they didn't know until they go in. Zakruski, the Florida Supreme Court.
I mean,
I'm
I just
sorry.
want to warn you, you're getting into your rebuttal time now. You've got 5 minutes left. You can use them as you wish.
I'll save it for rebuttal.
All right.
Thank you.
Thank you.
May it please the court. Andrew Crawford, I'm here on behalf of the appellee in this case, John Fultz. As the court knows, this is an appeal from the state's appeal from the denial of a motion to suppress. The Fourth Amendment, as the United States Supreme Court has noted, the chief evil it guards against is a warrantless entry into a home. When there is a warrantless entry into a home, it is presumed to be unlawful, and the state must overcome that presumption. In this particular case, the state traveled on the theory below and is traveling on the theory on appeal that there was some sort of exigent circumstance that would warrant these officers' entry into this residence. In this particular case, the facts below, which are undisputed, demonstrate that there were no 911 calls to this residence. There was no emergency medical calls to this residence. When officers arrived, there was no evidence of forcible entry. There was no blood. There was no reports of any type of domestic calls. There was nothing, as the court found below, that would indicate the medical emergency, the theory under which they're traveling. The cases cited in the state's brief, as Judge Sleet noted, are vastly distinguishable from the case here. In both the Ortiz case and in both the Riggs case, the officers were summoned to the particular location in reference to the concern for a child. That is something we absolutely do not have here. The only thing that the officers noted in particular at the time was an open door, a pile of mail, a light on upstairs, a car pulled up, and no one responding to the officers' calls when they approached the door. Other than that, there is no objective basis for the officers to enter this residence without a warrant. Because the warrant was obtained based on the officers' observations of going into the house, opening doors, the warrant was illegal, and the trial court properly concluded that the motion to suppress should have been granted. Is there any questions from the panel?
And for me.
Thank you.
So as I understand it, the court's main concern to differentiate these facts from the precedent facts are that the officers weren't called. Am I right in that?
No.
I have an issue with the fact that, and I still go back, I'm looking at the judge's specific findings
Okay.
and order, and the judge made a factual determination that it's obvious from the testimony that the search conducted in this case was not a routine welfare check.
Yes.
The court determined that it was not reasonable for these officers to go in based on the totality of the circumstances. So there is a factual determination based on the credibility that the trier of fact has done. And what troubles me is that in reviewing the argument that the state is asking us to reject that conclusion and simply say that no, based on the totality of the circumstances, it was quite reasonable for the officers to go in. And as an appellate court, we have to defer to the trier of fact when the trier of fact makes these determinations. That's my concern.
I recognize the court did make that specific finding that that they did not treat this as a normal welfare check. And they admit that because they did know they had this overlap of there's this meth lab tip that they just got, and they're fearful for themselves. So they did say, Officer Lovelace testified, we did take different precautions in entering this home. How that affects the reasonableness of what they observed to enter, I mean, that's recognized that they did treat it differently based on that additional fact, which is part of the totality of the circumstances. There's no suggestion in the court order otherwise, besides a suggestion that Officer Lovelace did intentionally choose that method of exit as opposed to exiting the way she came in. But that fact, we're not asking you to reevaluate that fact. That fact's irrelevant to the objective facts that both officers had in front of them.
But the suspicion of a meth lab without more, is that enough? Because you keep quoting Barth. If we're looking at the community caretaker function, Barth holds that the police must have a reasonable belief that a meth lab is being operated within the residence based on their experience, facts developed during investigation, and observation of the suspect's activities. That's what happened in Barth.
Right.
We have absolutely no observations of the suspect's activities here, and you would agree that these two patrol officers, despite their vast experience on the road and with law enforcement, they didn't have any specific drug training like Detective Taylor. And there were no facts developed during a drug investigation, particularly
they did
into
have
a
training.
math lab.
They did have training, but I agree they
But
weren't.
Lovelace and Deshay were not investigating a
Correct.
meth lab.
Correct, absolutely
And
correct.
these are the two that went in.
Right, because they weren't going.
Not Detective Taylor.
Right.
So I'm trying to figure out why you keep weaving in this knowledge of the meth lab.
Because it is part of what they know. It's part of what heightens their concern when they see.
It's part of what Lovelace was told at roll call. Is there anything else that she knew about this other than what she was told at roll call that morning? She was told at roll call about what the informant did.
Right, which corroborated what she had from residents who lived there, that there was some kind of drug activity. She didn't know anything about meth, but now it's like, oh, maybe it's meth. So that certainly affected part of the totality of how they handled this, how they looked at this situation. But nevertheless, they were going in based on the circumstances that we have discussed. The feared medical emergency, the feared burglary, and the fact that nobody called to alert them. Again, if an hour had gone by and a neighbor called, would that make a difference to this analysis? Where the law enforcement officer observes it herself.
Well, that's not the linchpin here. The linchpin for this panel is a review of the facts and circumstances before the officers and whether that was a objective basis for them to enter into this condominium without a warrant. All the cases you cited, the police were summoned. That's an issue, that's a factor, but that's not the linchpin here.
What I believe the linchpin is, as far as this court's analysis about why we could stand before you and ask you to review this, is not based on the facts, because we understand that we accept the facts that the trial court has made. It's based on the law where she is requiring a specific identified emergency, and that is not the standard under the feared medical emergency. We don't know what it is. Zakruski and Riggs both talk about uncertainty. They thought there was like child abandonment or harm to the caretaker, so that's why they went in. Here they think there's an ongoing burglary or somebody in there is needing help, and it does factor in the fact that they have this information about possible drug exposure. That could factor in. So here, the people that live in that apartment are being deprived of the caretaking function of the police, so that just because the police know about the potential meth lab, that is tainting what they otherwise would do for any citizen when they didn't want to go in there in the first place. And I don't think the judge does take issue with that. She takes issue with perhaps the motivation for choosing to go down that road when she
Ms.
exits.
Buffington, you've exhausted your time. You need to wrap up.
Based on Riggs, based on Zakruski, State asked this court to reverse the trial court suppression of evidence for misapplying the law to the facts that the trial court found.
All right.
Under the
Thank
feared
you
medical
both.
emergency. Thank you.